Chapter 2, Estates in Fee. The merger of the equitable in the legal estate in fee comes first for consideration. There is a rule in equity that a person cannot be a trustee for himself, therefore, when the same person has the trust or beneficial ownership, and also the legal estate, though they are derived under distinct titles, the trust will merge in the legal ownership. In Wade v. Peggy, the proposition is thus laid down: wherever the fee, simple in law and equity exist in the same person, there will be a merger of the equitable interest in the legal. And in Bridges v. Bridges, it is laid down as a universal proposition, that whenever the legal and equitable estates unite in the same person, and are extensive and commensurate, the latter is absorbed in the former. The equitable must merge in the legal, and it is immaterial by whatever means, whether by conveyance or otherwise, a person obtains the absolute ownership at law of the estate, though he acquired that by an equitable title, and both either come together or are afterwards united in him, the legal will prevail. The equitable is totally gone for the purpose of being acted upon by any person in a court of equity. Merger will operate so as to exclude one class of heirs as paternal heirs in favor of the maternal heirs, and the equitable fee becoming merged in the legal, the estate will descend ad feudum novum. The case of Goodwright v. Wells is an illustration of this. James Selby, sergeant at law, agreed for the purchase of an estate, and paid for it, but died before any conveyance was made of it to him, having by his will, made subsequent to the agreement, devised all the rest of his real and personal estate, whatsoever and wheresoever, to his said wife, in trust that she do throughout educate and maintain his said son until he should attain the age of 21 years, and until he should have sufficiently settled and secured to and upon his the said testator's wife what is to be settled upon and given to her as aforesaid, and afterwards in trust to convey and dispose of all the then rest of his real and personal estate, and the produce thereof, to his said son, his heirs, executors, administrators, and assigns. But in case his said son should die without issue before he should attain his said age of 21 years, then in trust, and c. after the testator's death a conveyance by lease and release was made of the estate to Mrs. Selby, the widow, who died before the son attained his age of 21 years. He afterwards attained that age, and died in 1772, having been always in possession of the estate after the death of his mother, and having devised it to charitable uses, which devise was void by the statute of mortmain. The lessor of the plaintiff was his heir at law on the part of the mother, and the defendants his heirs at law on the part of the father's mother. Lord Mansfield, after stating the case, observed, Sergeant Selby, after his purchase, was owner of the equitable estate, and has a right to go into chancery to compel a conveyance. After his death, the vendor conveyed to the widow, which conveyance, on the condition of the son's living till 21 and making a certain provision for her, was to be absolutely in trust for him. He outlived his mother, and on her death the trust estate was completely vested in him, the subsequent limitations being on contingencies which never happened, and the legal estate descended to him from her. The question is, to whom the whole estate descended on the death of the son, for it did descend, the devised to charitable uses being void. If it descended from the mother, the lessor of the plaintiff takes as heir at law. But it was contended that though he is heir, there is a trust for the paternal heirs, and it was said to be settled that the court will not suffer a trustee to recover in ejectment against the Sestuique trust. When this was mentioned on the trial I said, as I did the other day in the case of Doe v. Pott, that this rule is subject to the qualification of its being clearly the case only of a mere trust, for then, by taking notice of it, the court prevents delay and expense, but it will not decide where there is a doubt, but leave the question to a jurisdiction which regularly takes cognizance of matters of trust. The counsel said, there might perhaps be cases on the subject, and the parties wished to have the opinion of the court. Now who is to be considered as heir at law on this ejectment? It would be sufficient for the judgment which I shall deliver, to say that it is not a clear case that the lessor of the plaintiff is a mere trustee, for that point being doubtful, he is entitled to recover at law, as he certainly has the legal right. But I will go further, and throw out some observations to show that it is not only doubtful, but that the inclination of my opinion is that you cannot support such a trust. A case so circumstanced in every particular probably never existed before, and perhaps never may happen again. But cases must often have happened in which the general question would arise, viz. whether, when Cestuek trust takes in the legal estate, possesses under it and dies, the legal and equitable estate shall open on his death and be severed by the different heirs. Consider it first upon authority, and secondly upon principle. 1. No case has ever existed where it has been so held, none where the heir at law of one denomination has, on the death of the ancestor, been considered as a trustee for the heir at law of another denomination, who would have taken the equitable estate if that and the legal estate had not united. On principle it seems to me impossible, for, the moment both meet in the same person, there is an end of the trust. He has the legal interest and all the profits by his best title. A man cannot be a trustee for himself. Why should the estates open upon his death? What equity has one set of heirs more than the other? He may dispose of the whole as he pleases, and if he does not, there is no room for chancery to interpose, and the rule of law must prevail. The case in the Common Pleas, Doe v. Pott, is an authority, if it went upon this ground, and I am told it did. There the Cestuek trust taking the legal estate as a purchaser, the descent was altered quacum via data, therefore, the lessor of the plaintiff is entitled. If the question is doubtful, then, in this court the legal right must prevail, and if the weight of opinion and argument is that the legal estate must draw the trust after it, the case is still stronger against the defendants. Wiz. Justice, I entirely agree with my lord as to the legal estate, but my doubt is, what has become of the equitable use? Let us see how the facts stand. The money was paid by the father, but he died before any conveyance, devising as stated in the case. Now, what was the ancient use? It was to the heirs ex parte paterna. I do not agree that there is no difference as to the different heirs, when the question is between those of the paternal and those of the maternal line. The law always gives the preference to the former. After the father's death a conveyance was made to the widow and her heirs, in trust, so the estate in her was not absolute, but charged with the trust. Suppose the son in his lifetime had called in the legal estate and become a purchaser, there is no doubt but in that case the paternal heirs would have succeeded. There having been no such conveyance to him, the legal estate descended to him from the mother. But I think he took it clothed with the trust and subject to the ancient use. I do not say he was a trustee for himself, but this ancient use remained uncontrolled, and revived as between the different heirs on his death, no act having been done to alter it. If, therefore, the question were to come before me in another court, I should decree a trust in the lessor of the plaintiff. But he certainly is entitled to the legal estate, and that is enough here. Ashurst, Justice, added, we all agree that if there is a doubt as to the trust, the lessor of the plaintiff is entitled to the estate in this court, and therefore it is not necessary to give any opinion on the other point. But as it has been moved, I will mention that I am inclined to be of opinion that the trust, as well as the legal estate, shall go to the heirs ex parte paterna. To support the contrary position, it must be said that the son took as trustee for himself and his paternal heirs, for I do not see how the estate shall open for the heirs if he was not himself a trustee. I never knew any case where the court held, when an estate came by descent, that the heir was a trustee, although the ancestor was not. The case in the Common Pleas goes a great way to determine this question, for it shows, that where the trust and legal estates join, they shall both go according to the legal estate. Buller, Justice, observed, I am entirely of the same opinion with my lord and my brother Ashurst on both points. On the first we are all agreed. As to the second, it is observable that no case has been cited, nor do I believe any ever existed, where, in a court of equity, an heir of one sort has been determined to hold as trustee for an heir of the other sort. In a court of law, try the question by the principle stated by Mr. Batt, one of the counsel, viz. that, where two titles unite, the party shall be in of the best. What is the better title here? The clear fee, simple estate which descended from the mother. I think there is a mistake in taking the heirs on either side into consideration. They had no interest during the life of the ancestor, the whole was in him. The only person to be considered is the ancestor, who was seized in fee both of the legal and equitable estate. A case has been put which does not, in my opinion, vary the question, viz. the case of the sons having called for a conveyance. However, as the mother died before he came of age, and she was not directed to convey till then, that case does not apply. We are to take the facts as they stand. To be sure, if he had taken the legal estate by purchase, the paternal heirs would have been entitled, but as he took it by descent from his mother, and the case would have been the same if we suppose her to have lived beyond his age of 21, and that he never called for the conveyance, I think the trust was merged and gone. For the purpose of trying whether in this case the paternal heir had any equity against the maternal heir, a bill was filed in Chancery, and the case received a determination in that court in favour of the maternal heirs. Selby v. Adston. The court observed, "Then the next question is, whether upon the case made by the plaintiff he is entitled to an equity." The question at law was clear, there could be no question about that, but the judges intimated their opinions upon the equitable point. The argument of Mr. Justice Whiz was more equitable than legal. We have an intimation of the opinion of Lord Mansfield, and a strong opinion of the judges Ashurst and Buller against the equity. Mr. Justice Whiz's opinion was in favour of the equity. The question now is whether upon the case now coming before a court of equity the opinion of the three judges is such as this court will follow. I do not say the case is free from all difficulty, and there may be good reason to contend that the situation of the trustee shall not affect in any degree the estate coming from him to his Sestuique trust, but I must not lay that down too broadly, for that is not the fact. In Phillips v. Bridges, I stated as an universal proposition that, wherever the legal and equitable estates uniting in the same person are coextensive and commensurate, the latter is absorbed in the former. I stated, and I think I was warranted in so doing, that no act of the trustee can in any degree vary the right of the Sestuique trust, but I did not state, nor upon full consideration am I prepared to say, that it was ever held, that the situation of the trustee and the operation of the law arising from that situation, and the relation to the Sestuique trust, does not make considerable difference in the estates to be taken, as, for instance, supposing the trustee was an ancestor of the Sestuique trust and dies, and then the Sestuique trust dies, is there any doubt that his widow would be dowable? Though if the Sestuique trust died first she unquestionably would not. It has been argued that the trustee is a mere instrument, and his situation or act can have no effect at all upon the estate. I have put a case where, the fact being that the legal estate descends upon the Sestuique trust, and is united with the trust estate, he becomes solely seized at law, and both his widow and heir are entitled. Therefore the situation of the trustee, I do not say his act, may make a considerable difference. If the widow of Mr. Selby had conveyed to the son, it is clear he would have taken an estate descendable to his heirs ex parte paterna. Suppose she had made a fofement to the use of herself for life, remainder to her son, she would have had no intention of giving the estate in any new line. It is to be supposed that she would rather it should continue in the line that would carry it to her own heirs. But that act, though not done with that view, would have such an effect. So, where an heir takes by devise instead of by descent, the consequences are different, but that was never insisted on as a ground of equity. If an heir ex parte materna takes by devise, that would let in his heirs ex parte paterna, and if they fail, his heirs ex parte materna also. If he takes by descent he would only take an estate descendable to his heirs ex parte materna, and yet if he can take by descent the law makes him take so. The case of an escheat does seem a hardship upon the line of heirs that would have succeeded if Mr. Selby had taken from his father. That is the only argument that pressed upon my mind. Where the person himself has an equal coextensive estate at law and in equity, the legal shall prevail, notwithstanding the case I have put of the escheat. I have not found that courts of equity have ever upon that circumstance held that he is not to be considered as having a coextensive estate in law and in equity. The demurrer was allowed against the plaintiff claiming as heir ex parte paterna, and in Doe, Lessee of Balch, v. Pott and others, the paternal heirs prevailed against the heirs ex parte materna. The circumstances were these. It was an ejectment tried before Hewitt, Justice, at the Assizes for Somersetshire, and a special verdict was found which stated that Mary Mortimer being seized in fee of an estate of which the premises in question were an undivided moiety, on her marriage conveyed to trustees and their heirs, to the use of them and their heirs, upon trust to permit her to receive the rents and profits to her separate use during life, and to grant and convey the estate or any part thereof to the use of such person or persons in fee or otherwise as she, whether married or sold, by deed or will should appoint, and for want of such appointment to the use of the husband for life, remainder to her first and other sons in tail, remainder to her daughter in tail as tenants in common, remainder to her right heirs. The marriage took effect, and she died leaving her husband and an only daughter, an infant. The husband afterwards died, and then the daughter died, being still underage and without issue. The lessor of the plaintiff and 1 Newton were the heirs at law of the daughter ex parte materna, being the sons of 2 deceased sisters of the mother, and on the daughter's death they entered on the estate. The lessor of the plaintiff and the surviving trustee by lease and release, reciting as above, and that Newton had for a certain sum agreed to purchase the lessor of the plaintiff's moiety, and in consideration of the stipulated price conveyed that moiety to Newton in fee on the same day, by lease and release, also reciting as above, the trustee conveyed the other moiety in fee to Newton. Newton died, seized of all the estate, leaving the lessor of the plaintiff his heir at law ex parte materna, and the defendants his heirs at law ex parte paterna. The question on the special verdict was, whether the moiety conveyed by the surviving trustee alone to Newton, for which moiety only the action was brought, belonged to the lessor of the plaintiff or to the defendants. The court unanimously decided in favor of the latter, though it was contended that the legal estate should follow the old use which had come to Newton by descent ex parte materna, so that though Newton took nothing by purchase from the trustee but the mere legal estate, yet it was determined that the whole should descend from Newton in the paternal line, as in other cases of purchase, where the legal estate is outstanding and an infant dies seized of the equitable estate. A court of equity will not supply the want of a conveyance and consider it as made, where the conveyance would have the effect of altering the descent. The court never acknowledges any equity between 2 lines of heirs to alter the course of descent, nor is it the duty of a trustee, uncalled for, to execute a conveyance to an infant for the mere purpose of changing the line of descent. It would seem, however, that if an infant had requested the trustees to make such conveyance, the descent would in that case be altered. A subsequent title, which is both legal and equitable, destroys a prior equitable title. There must be a perfect union, however, of the legal and equitable estates to alter the course of descent or to confer a title to dower. Thus, in Knight v. Frampton, the legal estate of a property was vested in A, for the benefit of himself and B, in equal moieties. A mortgaged it unknown to B. Afterwards paid off the mortgage and had the legal estate conveyed to him, subject to such equity of redemption as the lands were subject to. So that B, during his life stood in this situation, that he had the legal estate in the whole, subject to the equity of redemption, an absolute equitable estate in a moiety, and an equitable title to have the legal estate in a moiety freed from the equity of redemption. And it was held that there was not such a perfect union of the legal and equitable estates in B.'s moiety of the estate as to give his widow a title to dower. In no instance can the legal estate merge in the equitable ownership but under the doctrine of attendant terms. The ownership of the equitable interest will give a claim to the protection and consequently to the benefits of the legal estate. The learning of merger had some influence in the establishment of the rule. For a term will not become attendant by construction of law, unless the term of the legal estate would have merged in the inheritance. But it may become attendant by express declaration, and after a term is once attendant, then any person who has any interest, however minute, in the equitable ownership, is entitled to a commensurate interest in the legal estate, and the legal and equitable titles are united, although the term and the inheritance remain distinct. The Attendant Terms Act, it should be observed, while merging every satisfied term of years which, either by express declaration or by construction at law, should upon the 31st of December, 1845, be attendant upon the inheritance, yet provides that every such term which shall be so attendant by express declaration shall afford the same protection as it would have afforded if it had continued to subsist. It will be proper to refer here to powers of appointment over the fee simple. Although not strictly belonging to the law of merger, yet the merger, or more properly, the extinguishment of powers, is a subject requiring considerable attention in the investigation of titles. where an estate was limited to such uses as he should appoint, and in default of appointment to himself in fee, great difference of opinion formerly prevailed, whether the power was not merged in the fee. It was considered that the separate existence of the power was incompatible with the ownership of the fee. But it is now settled that the power is not merged, when, however, the power is not created by the instrument under which the donee acquires the estate, but the power is granted at one time, and the fee is acquired subsequently. It would seem that the power will become merged by the accession of the fee. Thus in the case of Cross v. Hudson, before Lord Thurlow, an estate was conveyed to John Hay for life, with remainders over, with the ultimate remainder to the use of the survivor of him and his wife in fee. And a power was given him in the usual terms to appoint 1001 a year to take effect after his decease. He exercised this power by his will. His wife died in his lifetime, and all the intermediate remainders became incapable of taking effect, so that he was seized in fee, and Lord Thurlow held that the power was merged by the accession of the fee. Sir E. Sigden, while showing that the case of Maundrell v. Maundrell overrules the principle of the decision in Cross v. Hudson, observes, that with respect to the powers of leasing, jointuring, charging portions, and usually given to a tenant for life, it may be questioned whether these continue after the accession of the fee. Perhaps the better opinion is, that the powers cannot be exercised after the union of the estates, on the ground, not that the powers are merged, but that, according to the true construction of the settlement, they were not to endure beyond the continuance of the limitations which they were intended to overreach. Although in Cross v. Hudson, the power was held to be merged, yet the devise took effect out of the interest of the deviser, and so, where the powers have been executed by deed, the accession of the fee will not invalidate their execution. Merger cannot operate to the destruction of trusts. Courts of equity have never suffered mergers of trusts where the legal estate continued in the trustee, but have been against the merger if the justice of the case required it. The fifth circumstance enumerated by Mr. Preston is that the estates must not be privileged under the statute of uses. This statute exempts from merger cases wherein persons have a momentary say-eisen to serve the uses, and enacts that any estate in the releasee, FOFI, or grantee to uses will not be merged by its momentary union with the say-eisen, as it is transmitted through such releasee or grantee to serve the uses to third persons, as where A is lessee for years, and their reversioner infofs him to uses, the term is not merged. But where an estate by way of use capable of producing the merger is limited to such releasee, and C, of course his term will merge, but this merger does not arise from the transition of the momentary say-eisen, but from the union of his term with the new estate limited to him by way of use. The protection from merger above mentioned is afforded by one of the savings of the statute, and it is within the equity of this saving where the say-eisen is not merely momentary, but there are several conveyances making parts of the same assurance to raise the uses, and one of these conveyances gives the termer an estate which must remain in him until the instruments are brought into complete operation, as in Firma v. Firma. An executory interest cannot be destroyed by merger. The same person may have as distinct interests a fee, and also an interest to operate by executory devise to defeat that fee. Upon alienation, however, by the original owner, the two interests will be united. The conveyance will operate as a grant of the estate and a release of the executory interest, and so an executory devise of a term of years cannot be defeated by the merger of the term. Merger will take place in copyhold lands, in the same manner as in lands of freehold tenure. Thus, if two estates of copyhold tenure, one for life, and the other in fee meet in the same person, the copyhold estate for life will be merged. But when the copyhold tenant acquires any estate in possession, reversion, or remainder, in the freehold tenure of the same lands, he will cease to be a tenant by copy of court roll, and in this event his copyhold estate is not merged but the tenure of his estate is changed or extinguished. Estates tail in copyholds are exempted from merger, and an equitable estate tail in copyhold land will not merge by the accession of the legal fee.